For these reasons, the appeals chamber considers that the defense has failed to demonstrate weighing of evidence before it in the context of its consideration of the risk under Article 58(1)(b), subparagraph 2 of the statute. Trial chamber's reliance on the notion of a network of supporters, the appeals chamber recalls that it has considered that it is sufficient for a chamber to establish that it is possible that a suspect had the necessary assets to abscond, and that there is a risk that a suspect has the financial means to abscond on the basis of concrete evidence. The appeals chamber has also held that the existence of a supportive network and financial means may be relevant to determining whether there is a risk that a person may evade justice or interfere with the investigation, and that access to the international contacts would provide the means to enable a suspect to abscond, whether or not there was evidence that the suspect would actually utilize such contacts. In the impugned decision, in determining whether Mr. Duterte posed a flight risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber considered that he appears to have the necessary political contacts as well as to benefit from a network of support within the Philippines. The appeals chamber considers that contrary to the defense's argument, the pretrial chamber specifically outlined why it found that there existed a network of supporters in relation to Mr. Duterte, and for which reason this supported its conclusion that the risk under Article 58(1)(b), subparagraph 1 of the statute was established. In the view of the appeals chamber, the manner in which the pretrial chamber undertook this assessment was case-specific, as it took into account the specific circumstances of Mr. Duterte, amongst others, his position as former president of the Philippines and his recent re-election as mayor of Davao City in May 2025. It follows that the defense has failed to demonstrate that the pretrial chamber committed an error in assessing and considering Mr. Duterte's network of supporters for the purpose of its examination of the risk under Article 58(1)(b), subparagraph 1 of the statute. Further, under the first ground of appeal, by the pretrial chamber were irrelevant, the appeals chamber notes that when assessing the risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber relied on several factors in support of its finding that such risks existed. It relied on a statement by Mr. Duterte, statements by others, Mr. Duterte's position as the former president of the Philippines and his recent re-election as mayor of Davao City, as well as the matter of the gravity of the alleged crimes and concomitant sentence in case of conviction. The appeals chamber observes that the defense does not explain why, in its view, these factors were irrelevant to the pretrial chamber's assessment. Without more, the defense has failed to substantiate that the pretrial chamber's reasoning and assessment were unreasonable. The defense fails to demonstrate that the pretrial chamber's reliance on Mr. Duterte's re-election as mayor of Davao City in its assessment of the risks under Article 58(1)(b), subparagraph 3 of the statute was unreasonable. Moreover, With regard to the defense's contention that the pretrial chamber selectively cited facts and ignored others in the same items of evidence, the appeals chamber considers that the defense has failed to demonstrate how the fact Duterte that it cited should result in the pretrial chambers ignoring or attaching no weight other statements. Regarding gravity and concomitant sentences in case of conviction, it is recalled that the appeals chamber has consistently held that these factors are relevant considerations in assessing the risk under Article 58(1)(b) subparagraph 1 of the statute, as these are factors that may increase an incentive of a person to abscond. In the present instance, the gravity of the alleged crimes and the possibility of a lengthy sentence was but one of the factors the pretrial chamber took into account in its assessment of risks under Article 58(1)(b), subparagraph 1 and 2 of the statute. And it looked at the specific allegations against Mr. Duterte. It follows that the defense has failed to demonstrate an error. Regarding the question of whether the pretrial chamber erred in fact by failing to give appropriate weight to relevant facts, specifically Mr. Duterte's health condition and its mitigating effect on the risk factors set out in Article 58(1)(b) of the statute, as argued by the defense, the appeals chamber recalls that there is no provision in the court's legal texts that specifically provides for the interim or conditional release of a detained person on health grounds. Nevertheless, the appeals chamber has indicated that the medical condition of a detained person may have an effect on the risks under Article 58(1)(b) of the statute and may be a reason for a trial chamber to grant interim release with conditions. The appeals chamber considers that such a determination is necessarily case-specific. Contrary to the defense's assertion, nowhere did the pretrial chamber suggest that it was precluded from assessing the information about Mr. Duterte's health within the context of its assessment under Article 60.2 of the statute. Rather, it noted the reports placed before it and considered that they were unable to affect its finding on risks under Article 58(1)(b) of the statute. The defense has failed to show that the pretrial chamber's approach was unreasonable. For these reasons, having rejected the defense's argument under this ground of appeal, the first ground of appeal is rejected. I will now turn to the second ground of appeal. Under this ground, the defense challenges the pretrial chamber's assessment of the proposed conditions of release and state guarantees. The defense argues that the pretrial chamber erred in law in failing to address the proposed conditions of release and state guarantees. The appeals chamber is of the view that the pretrial chamber did not appear to criticize a lack of detail in the proposed conditions, but rather in the details as how the state which accepted to receive Mr. Duterte would implement the necessary conditions. The pretrial chamber did not consider release with conditions as required, but found that in the circumstances before it, the risks it had identified could not be mitigated by the proposed conditions. Moreover, the appeals chamber is of the view that the pretrial chamber was not obliged, as suggested by the defense, to seek further observations from the concerned state, because it did not envisage the possibility of release given the risks it found Mr. Duterte presents under Article 58 1b of the statute. For these reasons, the appeals chamber finds that the defense has failed to identify an error by the pretrial chamber when addressing the proposed conditions of release and state warrants. In relation to the question of whether the pretrial chamber erred in law by failing to consider if the proposed state warranties could mitigate the risks under Article 58 1b of the statute, the appeals chamber finds that this does not appear from the impugned decision that the pretrial chamber would have required an elimination of risks, as argued by the defense. Instead, the impugned decision specifically states that the pretrial chamber did not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the pretrial chamber when examining the implementation of conditions that it did consider them. When discussing potential release of the suspect to the host state, what matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the pretrial chamber's assessment are the conditions and warranties preferred in relation to a release to the state party concerned. For these reasons, the appeals chamber is of the view that the defense failed to substantiate the pretrial chamber's conclusions were unreasonable. All the three risks under Article 58 1b of the statute were established. As such, it was reasonable for the pretrial chamber to examine how, in practice, the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties. For the rejected. Third ground of appeal. Third ground of appeal, within which the defense argues that the pretrial chamber erred in not considering humanitarian grounds either as independent consideration or mitigating factor in assessing interim release, the appeals chamber considers that the pretrial chamber did not refuse to address the question of interim release on humanitarian grounds. Rather, it gave the reasons for which, in its view, the humanitarian grounds advanced by the defense were not sufficiently set out in the case at hand. Further, the appeals chamber recalls that the medical condition of a detained person may be a reason for a chamber to grant interim release with conditions, and that the chamber enjoys discretion when deciding on conditional release.